The federal courtroom in Washington, D.C. was a crucible of tension, its wood-paneled walls absorbing the weight of a high-stakes legal battle. At the center stood Pamela Bondi, the former Attorney General of Florida, now a defense attorney known for her tenacity in cases involving government overreach. Across from her sat the prosecution team, led by James Harrington, a seasoned Department of Justice (DOJ) attorney. Presiding over the proceedings was Judge Amy Berman Jackson, a 69-year-old Obama appointee to the U.S. District Court for the District of Columbia, renowned for her meticulous and uncompromising approach to justice. The case before them involved allegations of prosecutorial misconduct in a politically charged investigation, and what unfolded would reverberate far beyond the courtroom, exposing flaws in the justice system and reaffirming its capacity for self-correction. The hearing began with an air of anticipation. The gallery was packed with journalists, legal analysts, and curious onlookers, all sensing the potential for a newsworthy showdown. Bondi represented a former government official charged with obstruction of justice, a case that had drawn significant public attention due to its political undertones. The defendant claimed that the DOJ had deliberately withheld exculpatory evidence, material that could prove his innocence. Bondi, 58, was no stranger to high-pressure legal battles. As Florida's first female attorney general, she had tackled complex issues from healthcare legislation to drug trafficking. Now, as a private defense attorney, her reputation for methodical preparation and strategic foresight preceded her. The conflict escalated when Bondi began questioning the prosecution's handling of evidence. She suggested that critical documents had been deliberately excluded from discovery, the process by which the prosecution is required to share evidence with the defense. Judge Jackson, known for her strict courtroom decorum, issued a warning. "Ms. Bondi, these are serious accusations against the prosecution," she said, her voice tinged with irritation. "Unless you have concrete evidence, I will not permit this line of argument." Bondi, undeterred, responded calmly but firmly. "Your Honor, we have reason to believe that exculpatory evidence was deliberately withheld. If the court would allow me to present our findings—" "You've made these allegations repeatedly, Ms. Bondi," Judge Jackson interrupted, her patience visibly thinning. "Yet you've provided nothing substantial. This courtroom is not a stage for political theater or unfounded accusations against the Department of Justice." The exchange grew increasingly heated. Bondi, maintaining her composure, pressed on. "With all due respect, Your Honor, this isn't political theater. This is about justice and due process for my client." The courtroom buzzed with murmurs from the spectators, sensing the mounting tension. Judge Jackson's expression hardened. "Ms. Bondi, I've heard enough. Your comments are bordering on contempt." Bondi, standing tall at the defense table, her blonde hair framing a face that showed no fear, responded with a statement that sent shockwaves through the room. "Your Honor, if seeking the truth is contempt, then perhaps the standard for contempt needs examination." Gasps rippled through the gallery. The veteran judge, unaccustomed to such direct challenges, brought her gavel down with a force that echoed like a gunshot. "Mrs. Bondi, you are in contempt of court," she declared. "I am ordering the U.S. Marshals to take you into custody immediately." Two marshals approached hesitantly, their steps heavy with the weight of detaining a prominent attorney. Bondi raised a hand slightly, her voice steady despite the chaos. Your Honor, before you make a decision you'll regret, I believe you should review these documents. Her assistant rushed forward, placing a sealed folder on the judge's bench. The courtroom fell into an intense silence, every eye fixed on Judge Jackson as she narrowed her gaze at Bondi. Known for her tough rulings against high-profile figures, the judge reached for the folder with visible reluctance. What happened next would not only reverse her decision, but send shockwaves through the judicial system. Judge Jackson opened the folder, her expression shifting from dismissive to concerned as she scanned the first document. She glanced up at Bondi, who stood calmly beside the marshals, her posture relaxed, despite the threat of detention. "Where did you obtain these documents, Ms. Bondi?" the judge asked, her tone softer but laced with suspicion. "They were provided to us by a whistleblower within the DOJ, Your Honor," Bondi replied. "As you can see from the authentication markers and electronic timestamps, they are unaltered internal communications." The lead prosecutor, Harrington, rose quickly. "Your Honor, we have no knowledge of these alleged documents. The prosecution demands an opportunity to review them before the court proceeds." Judge Jackson silenced him with a raised hand. "You'll have your chance, Mr. Harrington. For now, I'm reviewing these materials myself." The tension in the room intensified as the judge continued reading, occasionally making notes. The prosecution team whispered urgently among themselves, while Bondi's client sat perfectly still, his eyes locked on the judge. After several minutes, Judge Jackson addressed the court reporter. "Let the record show that I am reviewing documents presented by defense counsel that appear to be internal DOJ emails and memoranda related to evidence in this case." Harrington stood again, his voice strained. "Your Honor, without knowing the source of these alleged documents, the prosecution objects to their consideration. They may be fabricated or obtained illegally." Judge Jackson's response was sharp. "Mr. Harrington, these documents bear official DOJ watermarks and appear to be from the department's secure internal communications system. Are you suggesting that Ms. Bondi or her team fabricated DOJ watermark documents?" Harrington faltered. "No, Your Honor, but—" "Then please be seated while I continue my review." The courtroom fell silent again as Judge Jackson turned to the next set of documents. Her expression darkened. "Mr. Harrington," she said after a pause, her voice cold but controlled, "these emails appear to show members of your prosecution team discussing the deliberate withholding of certain witness statements from discovery. Can you explain this?" Harrington paled. "Your Honor, without seeing the specific emails, I cannot comment on their content or context." Judge Jackson's eyes narrowed. "Let me read one for you then. Hammond's testimony contradicts our timeline. If we include it in discovery, the defense will use it to undermine our entire case. Recommend we classify it as non-relevant to discovery requirements." This email is dated 3 months ago and copied to your department email. Mr. Harrington murmurs swept through the courtroom. Bondi remained silent, letting the evidence speak for itself. Harrington, visibly flustered, attempted to respond. "Your Honor, if such an email exists, it was clearly discussing a legal determination about relevance, not suggesting improper withholding of evidence." Judge Jackson's tone was icy. "Is that so? Then how do you explain the response, also copied to you?" "Agreed. File Hammond's statement separately from the main evidence. Mark it as internal work product to shield it from discovery requirements. Mr. Harrington, are you familiar with Brady v's Maryland? Of course, Your Honor, Harrington replied stiffly. Then you're aware that the prosecution is legally obligated to disclose evidence that might exonerate the defendant, Judge Jackson said. These emails suggest a deliberate strategy to circumvent that obligation. The marshals, still standing near Bondi, exchanged uncertain glances, unsure whether to proceed with the contempt order. Judge Jackson turned to the next document, her expression shifting to shock. This document appears to be a sworn statement from Thomas Hammond, a key witness in this case, directly contradicting the timeline presented in your opening arguments. According to your own filing system number, it was in your possession 6 months ago, yet it appears nowhere in the discovery materials provided to the defense. Harrington began to speak, but Judge Jackson cut him off. Even more concerning, Mr. Harrington, is this email from you personally, instructing your team to ensure Hammond understands the importance of consistency with our established timeline before his testimony. Would you care to explain what you meant by that? The courtroom erupted in shocked whispers. One of the junior prosecutors buried his head in his hands. Bondi finally spoke. Your Honor, there are 17 more examples of withheld exculpatory evidence outlined in the remaining documents. Given what we've uncovered, we move for immediate dismissal of all charges against my client and request a formal investigation into prosecutorial misconduct. Judge Jackson set the documents down and looked at the marshals. Gentlemen, you may return to your stations. The contempt order is rescinded. The courtroom buzzed with astonishment. What had begun with Bondi facing detention had transformed into a devastating exposé of prosecutorial misconduct. Judge Jackson, known for her by-the-book approach, now faced a decision that could define her legacy. She removed her reading glasses and closed the folder deliberately. The court will take a 30-minute recess, she announced. Mr. Harrington, I expect you and your entire team to remain in the building. Ms. Bondi, you and your client will also stay. Court is in recess. As Judge Jackson exited, the courtroom exploded into a frenzy of whispers and movement. Journalists rushed to file reports, their initial headlines capturing the dramatic turn of events. 30 minutes later, the courtroom refilled to capacity, with additional spectators crowding the back wall. Judge Jackson returned, her expression grave. Before I address the serious matters before us, she began, I want to make something perfectly clear. This court's primary obligation is to justice and the rule of law, not to any political agenda, not to any individual, and certainly not to protecting the reputation of any institution, including this court. She turned to Bondi. Miss Bondi, I owe you an apology. My contempt order was issued hastily and without proper consideration of your claims. As officers of the court, attorneys have not just the right, but the duty to zealously advocate for their clients, especially when there are concerns about procedural fairness. Murmurs of surprise rippled through the room. Judge Jackson was not known for public apologies. She continued, However, the manner in which you presented your accusations without prior notice to the court created an unnecessarily confrontational situation. In the future, I would expect such serious allegations to be presented through proper channels. Bondi nodded respectfully. Understood, Your Honor. The timing of our receipt of these documents presented unusual circumstances. Judge Jackson then turned to the prosecution table, where Harrington sat ashen-faced. Mr. Harrington, the documents presented by the defense contain extremely troubling evidence of what appears to be deliberate prosecutorial misconduct. The withholding of exculpatory evidence is among the most serious breaches of prosecutorial duty. Harrington stood slowly. Your Honor, if I may— You may not, Mr. Harrington, Judge Jackson interrupted, her voice like steel. I have reviewed these documents thoroughly during the recess and consulted with the Chief Judge. Based on the evidence before me, I am taking the following actions immediately. She held up a document prepared during the recess. First, all charges against the defendant are dismissed with prejudice. The defendant closed his eyes in relief, while Bondi maintained her professional composure. Second, I am referring this matter to the Office of Professional Responsibility at the DOJ for a full investigation into the conduct of the prosecution team. Harrington's shoulders slumped. Third, I am ordering an independent review of all cases handled by this prosecution team over the past 5 years to determine if similar misconduct has occurred. A junior prosecutor gasped audibly. And finally, Judge Jackson continued, I am self-reporting to the Judicial Conduct Committee my handling of this case, including my initial dismissal of the defense's concerns and the contempt order against Ms. Bondi. The courtroom was stunned. Even Bondi looked surprised. Your Honor, she said, rising, while we appreciate the court's reconsideration, self-reporting seems unnecessary. You corrected course as soon as evidence was presented. Judge Jackson shook her head. Miss Bondi, the integrity of our judicial system depends on accountability at all levels. If I demand it from the prosecution, I must demonstrate it myself. She addressed the room. What we have witnessed today is both a failure and a correction of our system of justice. The failure lies in the apparent misconduct that nearly resulted in an unjust prosecution. The correction comes through the diligent work of defense counsel and the system's capacity, though sometimes delayed, to right its own wrongs. Turning to Bondi, Judge Jackson added, Miss Bondi, the court acknowledges that without your persistence and the evidence you obtained, a serious miscarriage of justice might have occurred today. While I don't condone the confrontational approach, I cannot dispute the importance of the outcome. Bondi nodded. Thank you, Your Honor. The defense appreciates the court's reconsideration and decisive action. In a final gesture, Judge Jackson addressed the marshals. Gentlemen, thank you for your restraint and professionalism today. It serves as a reminder that even when carrying out orders, measured judgment remains essential. With a final strike of her gavel, Judge Jackson declared, This case is dismissed. Court is adjourned. The courtroom erupted as spectators and journalists rushed to spread the news. Bondi calmly gathered her documents, having entered the courtroom facing detention and left having exposed serious misconduct, secured her client's freedom, and earned the respect of one of the nation's toughest judges. It was a victory not just for her client, but for the principles of due process and the pursuit of truth, principles she had risked her freedom to defend. The aftermath was seismic. By nightfall, the drama had exploded across news networks and online platforms. Video clips of Judge Jackson rescinding her contempt order and dismissing the case went viral with hashtags like number Bondi versus Jackson and number Justice Restored trending nationwide. Legal analysts dissected the hearings every moment. A former federal prosecutor commented, "What we witnessed was extraordinary. Judge Jackson is known for running a tight ship and rarely backs down. For her to reverse a contempt order, dismiss the case, and refer the prosecution for investigation speaks to the severity of what Bondi uncovered." The political implications were equally significant. The case, viewed by many as politically motivated, reinforced concerns about the weaponization of the justice system. Conservative commentators praised Bondi's courage, while liberal legal scholars acknowledged the importance of exposing prosecutorial misconduct, regardless of political alignment. A prominent civil liberties attorney noted, "The system worked today, not initially, but eventually. Justice requires vigilance and, as we saw with Pam Bondi, considerable personal risk." Within 24 hours, the DOJ announced Harrington's reassignment and the formation of a special review team to investigate the allegations. The Attorney General issued a statement. "The integrity of our justice system depends on prosecutors fulfilling their ethical and legal obligations. Any deliberate withholding of exculpatory evidence is unacceptable and contrary to DOJ values. We take these allegations extremely seriously." For Bondi, the aftermath brought professional accolades and personal reflection. In her first interview, she said, "This wasn't about me or Judge Jackson. It was about ensuring that our justice system functions as it should. When prosecutors withhold evidence, they're breaking the foundational trust upon which our legal system depends." Asked about facing jail time, she replied, "There are moments when you decide what matters most, personal comfort or professional integrity. I knew the risk, but I also knew what was in those documents." The whistleblower who provided the documents remained anonymous, but their impact was profound. Additional information surfaced, suggesting that evidence suppression might not have been isolated. 3 other cases handled by Harrington's team came under review, raising serious questions about their handling. Judge Jackson, true to her word, submitted a self-report to the Judicial Conduct Committee. In a public statement, she said, "Judges are human, and humans err. Integrity is not never making mistakes, but how we respond when those mistakes are revealed. The judiciary must hold itself to the same standards it applies to others." Legal experts praised her accountability, with one noting, "Judge Jackson's willingness to acknowledge her error and subject herself to review strengthens her reputation." 6 weeks later, an official review concluded that Judge Jackson had acted appropriately in correcting her error and recommended no disciplinary action, citing her transparency as exemplary. The defendant, now exonerated, filed a civil rights lawsuit against the DOJ, with experts predicting a settlement to avoid further exposure of the department's failures. The case catalyzed broader discussions about prosecutorial oversight and the challenges defense attorneys face when misconduct is suspected, but hard to prove. Several members of Congress cited the case when introducing legislation to strengthen Brady disclosure requirements and establish remedies for violations. Law schools incorporated the case into their legal ethics curricula, with one professor noting, "The Bondi-Jackson confrontation illustrates both the fragility and resilience of our justice system. It's a reminder to future lawyers that ethical courage sometimes requires personal risk. For the public, the case offered a rare glimpse into the justice system's mechanisms, both when they falter and when they correct themselves. Polls showed increased awareness of prosecutorial disclosure obligations and concern about potential abuses of power. A year later, Bondi and Judge Jackson appeared together at a judicial conference panel titled Adversaries in Court, Allies for Justice. Their joint appearance symbolized how two strong-willed legal professionals, despite their dramatic clash, shared a commitment to justice. "What happened in that courtroom was difficult," Judge Jackson said, "but the outcome, exposing misconduct, preventing an unjust conviction, and prompting systemic review, served justice in the highest sense." Bondi agreed. "The adversarial system works not despite our tensions, but often because of them. When we each fulfill our roles with integrity, justice emerges, even if the path is dramatic." The case would be remembered not just for its drama, but for demonstrating that in America's justice system, even the most powerful can be held accountable when evidence and truth prevail. It was a testament to the courage of a defense attorney, the accountability of a judge, and the enduring strength of a system that, though imperfect, strives to correct its wrongs.